Let's welcome the second speaker of this session, Dr. Rui Guo. He's an associate professor at the Law School of the Renmin University of China. He also is the fellow of the Harvard Law School Project on Disability. Professor Guo spoke ethics and governance of artificial intelligence has been well received by the academia community and the public. Today, his talk is the long march towards the AI fairness. Dr. Guo, please.
Okay, can you hear me well?
Yeah.
Okay, great. Thank you, and it's my honor to speak here today. So I think you've all received the abstract. Maybe let me say a few words about fairness.
Professor,
the ideas about
not see the slides. Have you shared? Yeah.
See.
And you may open the captain, Chinese captain, and there will be more audience on the live broadcast. There are most of them in the Chinese local audience. Yeah.
Okay, great. Okay, let's see. Do you see the slides?
Yeah, you can see that.
Okay, wonderful. Okay,
yeah.
So the long march towards AI fairness. So thank you. Let me say a few words about fairness. The ideas about fairness belong to a broad field. I think both the keynote speaker and Professor Feng mentioned it's a field called ethics. This is a field of knowledge on good and evil. Humans desire to tell good from evil, judge foul or fair, and ponder on freedom and responsibility. These are all ethical thinking. Depending on one's attributing to the knowledge of good and evil, ultimately to the subjective or to the objective world, people follow the paths of deontological and consequentialist approach of ethics. The deontological theory, represented today mostly by Kantian ethics, takes the freedom of the subject as the ultimate criteria, and men must follow a set of principles derived from it. These principles, as we mentioned earlier, come from the subjective world. The consequentialist theory goes in the opposite direction, where the results of human actions in the objective world becomes the ultimate criterion for judging human activities. So, yeah, applying to the question of fairness, or probably more specifically, on whether discrimination exists or not. Lawyers, legal scholars, often look for problematic usage of certain protected factors or social group categories in one's decision or actions in order to identify prohibited activities that leads to questionable consequences. This, of course, has caused problems in the context of AI. Unlike in the case of discrimination by human beings, we do not have direct evidence, like smoking gun evidence, when the decision maker explicitly use certain protected factors or social group categories, such as race, age, or sex. So if one suspects in the context of AI that discrimination exists, besides identifying statistical patterns, one still has to find somewhat subjective actors. This is why some scholars argue that if these factors are implicit in the data, they should be altered or to avoid it in order to prevent discrimination. But more often, this approach is problematic. The group criteria, such as race, sex, age are unavoidable in AI model. Getting rid of these factors has caused more problems than what it solved. Even if it works, it is only addressing a limited set of problems. So today, I will give an example to demonstrate one of these types that such an approach does not help. And I'm specifically going to discuss discrimination caused by stereotypes. So I will be using a hypothetical case about disability discrimination in employment context. Here's the hypothetical case. So a person with a physical disability, for example, a wheelchair user, submits a resume to a company for a management position in an open recruitment. So the company uses a deep learning model Y to screen the resume. The model was trained using historical data from company X's for the past 10 years. Company X has recruited and hired 50,000 employees in the past 10 years, including 25 employees with disabilities. So this model takes into consideration of the following indicators: how often the candidates went to work on time, how much amount of time the candidate spent away from office seat, and how highly the previous employers evaluate the candidates. So A's resume was screened out by AI and it was rejected the job. So A filed a lawsuit in court claiming that the company has used AI discriminated against him. So that's the hypothetical. Let me point out before we discuss AI discrimination that same mistake could be made by a human individual. Although, often in an ordinary member of the society's view, AI discrimination is more likely to appear objective and fair, and more difficult to correct. So, but we're looking at the AI discrimination. So let's turn to close examination. So first, let's look at the training data. So the model uses employment data from the company for the past 10 years as training data. It sounds okay, but ignores the possibility that the composition of the employees hired by the company over the past 10 years may not itself satisfy the representation of employed persons with disabilities. When we look at the hiring rate, the company X recruited and hired only 5 among 10,000 employees with disabilities. This is significantly less than the percentage of the disability population in the whole population. So without satisfying the independent identical distribution condition, the algorithm's hiring decision for the disabled population are likely to have higher error rate. The errors are likely leads to discrimination results. So second, let's look at the indicators taken into consideration. So the first and second factor indicator appear to be part of an objective evaluation of the willingness to work. So these indicators are how often the candidates went to work on time, how much amount of time the candidates were away from office seat. So they look objective, but we should notice that there are actually proxies for willingness to work, not direct measuring of the willingness to work. The first indicator, whether a wheelchair user can come to work on time, might not reflect the willingness to work. For instance, the accessibility of buses and subway may directly relate to this proxy. If buses do not accommodate wheelchair users, their coming to work not on time does not show lacking willingness. Similarly, the time spent away from the office seat during work hours may depend on the accessibility of the workplace. For example, whether or not there's a accessible toilet for wheelchair users. So the employee may need to travel long to go to a bathroom, and this necessarily leads to less time in office seat. So these indicators seemingly objective, but they may be problematic. The third indicator is even more problematic. So the model used the evaluation of the previous employer. So this is often used in a hiring process, but we should be cautious about this indicator, because if the former employer's evaluation was discriminatory, the indicator simply passes this bias to the model. So the importance of data in determining whether the AI model has discriminatory features is unquestionable. So we're mostly looking at three aspects of the problems. First, if the data used lacks proper representation of the protected population, then AI decisions for the protected population are more likely to have higher error rate, which leads to AI discrimination. Second, if the data used is not direct measurement, but simply proxies, then the error rate of the AI decision for the protected population may increase and eventually lead to AI discrimination. Three, if the data used to train the model contains bias, and this bias may pass to the model. So behind the data problem is a larger problem. The problem we identify from the three groups of indicators originates from stereotypes. Stereotypes are a set of socially shared, solidified, superficial, and often negative perception about the characteristics of members of a particular social category. In the current case, disability categories lead to preconceived negative impression of the candidates with disability, or unawareness and lack of critical evaluation of the indicators. So from a disability study, we know that for most of the employers, they may, when they make decisions that discriminate the persons with disability, they may perfectly think themselves making the right decision, and view their refusal to hire people with disability merely an objective evaluation on their willingness and ability to work. The perception by the employer is, widely supported even by the society. So the roots of this public stereotypes about the persons with disability can be traced back to a lot of other things: laws, policies, and even culture. For example, legislation or policy often presuppose people with disability as recipient of special assistance or social services rather than equal participants in society. I should mention that the United Nations Convention on the Rights of Persons with Disabilities, we call CRPD, recognize a social model of disability. And this model strives to protect the rights rather than giving special assistance. Because behind all these efforts to special assistance is a biased goal of normalizing them. And failing that, it points to making special segregated placement of them rather than ensuring their equal participation in society. So CRPD is an effort to uproot this broadly shared stereotype on disability and strive to make social changes. And it is so far a very successful international treaty, and a lot of countries, including China, have made legislative changes, modified laws to be inconsistent with CRPD. So this is a case from disability discrimination. So, but when we step back and looking at a general problem of AI fairness, we realize that when we look at an ethical problem such as AI discrimination, we assume that either the AI model malfunctions, or AI executes a human will that intended to discriminate, or AI execute a human will that did not intend to discriminate, yet the consequence misaligned with the original intent. This, I should say, is a model of moral agency. We somehow think AI may make decisions that not necessarily for the best interest of ours. We want to make decisions by ourselves, or entrust when we entrust those decisions to AI, and they have to make decisions inconsistent of our values. Ethical problem we often see, they appear when AI fail our trust. But we should see that the problems are not limited to what the moral agency model points out. Of course, there are a lot of discussions on whether AI model could be a moral agent. As a moral agent, AI needs to have the consciousness, freedom, and will. And any one of these three, when we look at AI, a lot of people think they might not even have any one of them. So, and furthermore, most of the decisions AI could have made without our knowledge, or it could be very long before us to realize the problematic nature of the decisions we entrusted to AI. So without our knowledge about these decisions, we cannot detect what's wrong and how we should respond to it. So in these scenarios, a moral agency model simply doesn't apply. So zooming out of the moral agency model, I think we should look at a bigger picture, and the problem, as I call it, I think a better characterization of the problem is the crisis of the order of creation, which I discussed in my book. So simply put, we should know that AI is not simply extending human reach or amplifying human powers, but AI has made human encounter this crisis. And this crisis originates from two problems. So first problem, the problem of ultimate moral principle, and second problem, the problem of causation. These are problems that we don't see any easy solution, and any given AI system is imbued with these two unsolvable problems, given the conflicting human desires and limited human rationality. So when we recognize the crisis of the order of creation, we then find that an AI system may have somewhat a will or a bias that is self-contradictory and difficult by any individual to deal with. And it takes a societal effort to change and uproot any of these problems, such as a stereotype. So in the disability studies, we learn that the situation changes when there's a better awareness of the problem, and when there's social movement to help change the situation. So as we learn from the disability discrimination and CRPD, this may take a long time and relies on everyone, including especially the tech community support. I hope this presentation will be helpful and intriguing for you to join the cause. And that's all my presentation, and thank you very much.
Thank you very much for this brilliant speech, Dr. Guo. Impressive cases give us more touch and understanding of the challenge of the fairness. Hope we and more researchers and related people can work together to solve them with better in the future. Okay, here comes the Q&A session. Let's see, is there any question?
Yeah, I'd like to ask a question.
Please.
Professor Guo, I think your talk is very impressive, and I learned a lot. Actually, currently, I see many people are discussing how we can develop laws, especially for artificial intelligence. So how do you think, for example, fairness or maybe other topics like privacy or transparency, could we develop related laws in a few years?
Right. Thank you, Dr. Xie. I think I actually learned more from your overview of the field about whether or not we could easily have legislation. So I think we Chinese legislators have worked on personal information law, and of course in the civil law code there's general provisions. So in the field of law, we don't tend to think there's a vacuum, even if the question is very new. Novel problems could be solved by interpreting the existing law. I think whether or not we're trying to develop a new legislation or simply interpret the old rules to cover the new cases, we're trying to kind of dig out the moral and legal resources we have to solve the problem. Frankly, I think the legal academia and legislators, policymakers, myself included, we still have a lot to learn. I think the development of AI technology is simply just too fast, and law is a very conservative field. So we need to learn a lot before we can be confident that we could develop, legal principles to solve the problem. For sure, we have seen cases arise, and I think, in general, courts and the legal academia have been kind of conservative in interpreting and limiting the problem, not to make too broad claims. I think that's healthy. So I'm not sure whether that answers your question, but
yeah, thank you. Yeah, I think interpreting existing laws, that's a very good approach. Yeah, thank you.
Thank you.
I see Professor Fang has a question.
Yeah, I have a question. Thank you, Professor Guo. That was very, very illuminating. I actually have this general question for the law, for our colleagues in the law profession. So how can we avoid over-regulating AI or innovation in general, technology, and also under-regulating? Meaning that I have actually interest, right, as a AI developer or algorithm designer. On one hand, I don't want innovation to be stifled by too much regulation, especially overfitting regulations that overfits to what I'm doing today. On the other hand, I also want to have regulations because then it will make my job easier. If you tell me in detail what I should do, then I can do things more easier. For example, user agency is very broad, right? It's very generic. However, if you tell me for every system with recommendation engines, I must let user to turn it off, right? This is one recent regulation from China. So that makes our job easier, right? But on the other hand, if you overregulate, overfit to the existing technology, then it will become obsolete down the line, or it would. How do you guys, like in the legal profession, balance between the two?
Thank you. That's excellent question, Professor Fang. So I learned a lot from your talk, and I hope after this I could continue to learn from you. I have a couple of examples about. It's not sort of anything successful, but rather lessons we have learned. One from the AI fairness. So one of the kind of overreach example of law is that somehow, at least in some of the jurisdictions, not necessarily in China, people tend to think that if sex, race causes discriminatory treatment, then researchers or business companies should simply take away these factors from their model. And of course, that's just oversimplification of the problem. And when you take away these factors, the whole model becomes not accurate and sometimes even not useful at all. So I would, I think legislators should avoid these oversimplified solution of a very complicated problem. And I have critical view about, as a second example, I have critical view about this regulation to mandate that any of the recommendation system should allow users to turn it off. Behavior economics shows that our human brain just have very limited capacity to remember things and to process information. When the system turn off, when the regulator just simply mandate that personalized recommendation must be turned off, consumers sometimes ended up not in better situation but worse situation. So personally, I think it's also an example of oversimplified solution of a complicated problem. So as I said, Professor Fang, I think legal academia needs to learn, and legislators need really to consult broadly before any significant legislation. So AI is still a very new field. It's still, I think it's changing a lot of our relationships in society, and it's only normal that we see there are some not so successful examples, but I think trials and error isn't always a stage for developing better legal system. So I hope we will have more successful examples in the future. Thank you for your question, Professor Fang.
Thank you, Professor Guo. Thank you.
Thank you. I joined the discussion. We can leave more discussion in the following panel discussion. And thank you again for Professor Guo for this wonderful speech and answering questions.